Good evening. My name is Noeline Smart and I'm Solicitor and Barrister of the Supreme Courts of Victoria and New South Wales. I wish to make this public statement in my capacity as an independent observer, without any affiliation or association to any particular individual or political party. The purpose of my statement is to share with you my analysis and views on a particularly controversial topic which has taken over the Sri Lankan public domain. This is none other than the issue of parliamentary appointments from the national list. By way of introduction, let me first explain to you what the legal framework of the national list is. Pursuant to the 14th Amendment to the Constitution, provision is made for the appointment of persons with leadership talent as members of Parliament following an election through what is known as the national list. This is a constitutional mechanism which is contained in Article 99A of the Constitution. Now, Hansard records from the 4th of May 1988 in relation to the third reading of the 14th Amendment Bill confirms its objectives and intentions. Now, it was so that subject matter experts who may be otherwise be unable or unwilling to be appointed as members of Parliament through an election could still participate in the country's lawmaking process and at times even become members of the executive. Now, the scope of the national list in this context is nothing but noble and justified, even made necessary when popular politics cannot always be relied upon to bring together the best talent in a country to a single platform such as the Parliament. Now to the issues we need to establish in the present context. The first of these issues is whether due process was followed in the context of the 14th Amendment, particularly in relation to the establishment of the national list. This is because the 14th Amendment attempts to amend Article 4A of the Constitution, which states that the sovereignty of the people shall be exercised by Parliament consisting of elected representatives. The question is whether, despite the oppression of Article 83, whether an amendment to Article 4A also requires a mandate from people at referendum. Now, here appears to be a question of constitutional interpretation. In the past, it has been held by the Supreme Court that Article 3 is not enforceable without making Article 4 an entrenched provision. The court has used its inherent jurisdiction to conclude that Article 4 is to be an entrenched provision, which means it cannot be varied or amended without first having obtained a mandate from the people. Article 125(1) of the Constitution vests in the Supreme Court exclusive jurisdiction and power to determine these sorts of issues. Conversely, any attempt by the Supreme Court to avoid determining these issues would amount to a gross failure to exercise its duties, causing to crumble the fine architecture of our democratic legal framework. Now, it is my understanding that this matter is to be fully litigated. I am confident that such judicial review process will ultimately decide these issues. Now, if in fact such a review concludes that the national list in its present form is unconstitutional, then the matter will have to become the subject of a referendum, and it will be up to the general public to determine whether the national list should continue to be a system through which at least some parliamentarians could be appointed. I would now like to turn to the second and which appears to be the more pressing and controversial matter at hand. Here there is a presumption as to the constitutional validity of the national list. The principle of ultra vires may also have some application here, particularly in the context of the various roles which are played by different arms of the government in appointing members under the national list to Parliament. Now, here I would like to quote section from Article 8 of the 14th Amendment as relevant to our discussion. Every recognized party or independent group contesting a general election shall submit to the Commissioner of Elections within the nomination period specified for such election a list of persons qualified to be elected as members of Parliament, from which it may nominate persons to fill the seats, if any, which such party or group will be entitled to on such apportionment. The Commissioner of Elections shall cause every list submitted to him under this article to be published forthwith in the Gazette and in one Sinhala, Tamil and English newspaper upon the expiry of the nomination period. In other words, here is a prescriptive duty to disclose and publish a list of candidates who will be considered for appointment by the respective political parties. It will therefore unambiguously be unconstitutional and unlawful to deviate from this process, which is set out in the 14th Amendment. The law-making power is clearly set out in the Standing Orders of the Parliament, which prohibits any amendment to a bill that would violate the primary objective of a bill presented to the Parliament. Now, the remedy, I would say a declaration by the Supreme Court under Article 82(6) of the Constitution that states that Article 99A has not been duly enacted, and in terms of the process set out in Article 82(5) of the Constitution. And therefore, the entirety of the 14th Amendment, which contains the nationalist provisions, is ab initio void. It is indeed an absurd situation if any political party could use this mechanism to sneak in party favourites who have not received the democratic endorsement of successful election. To put quite simply, smuggling into Parliament failed candidates or even friends and relatives of party leaders is an attack on the sovereignty of people, and any such action would cause the total erosion of the concept of democracy. Allowing backdoor entry to Parliament through an unconstitutional and ultra-vires process makes a mockery of the Sri Lankan legal framework. These appointments then usurp the sovereign power of the people by engaging in a law-making process which you, the general public, did not mandate. Question yourself whether some of the political and economic disasters you're facing today may be the result of such laws passed in Parliament purporting to exercise power on your behalf. Now, some of you may wish to be tolerant of the present situation, reconciling yourself to accept the appointment of some MPs who were never in the original list, and this could be because of such matters as familiarity or even a sense of trust and optimism. Alarm bells should now ring loud and clear, because tomorrow's appointments through the national list may not be as tolerable as today's. Do not support or accept any mechanism that undermines the rule of law or the Constitution, because to do so is to welcome corruption and disappointment you do not want for this country. Emerging now in the public domain are documents which allegedly lacks authenticity. The unavoidable question is whether these documents have now been produced to justify past actions. These allegations require immediate action by both the executive and the judiciary. If in fact it is proven that fake documents have been created, it will be an act of treason, as this amounts to an attempt to usurp the powers of the legislature. I believe that the time to seek answers is now. Do not be deluded by popular views simply because they are published in the media or presented to you in such a persuasive manner. Be strong enough to question the lawfulness of matters that affect your rights as a private citizen, and not just as a member of a community. Democracy, as you know today, was a hard-won privilege. Universal franchise, one of the biggest wins in the annals of Sri Lankan political history, which has only been the case since dawn of more times, is a fundamental tenet of this legal and political system. I hope you will all have the will to defend this institution with utmost vigor and passion. And as I always say so passionately, long live democracy. Thank you.